You've been released. Next witness.
Michael Mummert.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Mummert.
Good morning.
How are you doing today?
I'm doing well.
Can you please state and spell your name for the record?
Michael Mummert, M-I-C-H-A-E-L, last name M-U-M-M-E-R-T.
And how are you currently employed?
I am the owner and principal attorney at Mummert Law Firm.
How long have you owned your own law practice?
It's 2018.
Okay. I'm sorry, 2018.
18.
Okay. What is your main area of practice in your law firm?
Currently it's family law.
Okay. And how long have you been a member of the Florida Bar?
Since 2005.
You've been practicing for 20 years?
Yes.
Going back in time, can I ask where you, after passing the Florida Bar and becoming a licensed attorney, where did you first practice law?
First, briefly with Coleman, Hazard and Taylor, a civil law firm, and then I went to the public defender's office, which was where I spent the next 8 years.
And was that the local public defender's office?
Yes,
Here?
I did about a year and a half here in Fort Myers, and the remainder of the time in Collier County.
Is that all within the 20th Circuit?
It's all been in the 20th.
What types of criminal cases did you handle at the PD's office?
Everything from misdemeanor DUIs. I had a very brief stint in juvenile, and I handled all manner of felonies, including felony murder. So, yeah.
Did you handle any capital cases while employed at the PD's office?
I did not handle any capital cases.
And what year did you leave the PD's office?
2013.
And where did you go after the PD's office and prior to starting your own firm?
I went to the Fega Law Group. Tony Fega, who's now deceased, owned the Fega Law Group, so I went and worked with him.
Were you still practicing criminal law with Mr. Fega, or is that when you started your pivot to family law?
That's when I started my pivot to family law, but I was still actively practicing criminal defense.
Would you say at the time of either when you started with Mr. Fega to at the time of when you took on Mr. Sievers' case 2015, 2016, were you still handling criminal cases, or were you doing a majority of family law?
I was still handling criminal cases.
What types of criminal cases were you handling?
Misdemeanors, I believe I had a trafficking case, conspiracy to traffic case. At that time, I believe I had, I had taken on a couple sex crimes, really just kind of all over the place, but still generally, misdemeanor felonies.
How many jury trials would you say you've completed?
At present, I've had well over 40 felony jury trials, and as far as misdemeanor jury trials, I couldn't tell you.
Just want to fast forward to your involvement with Mr. Sievers' case. How did you get involved with this case?
So Mr. Fega asked me to go and talk to Mark about the dependency case.
Okay, so the first interaction was not involving the criminal case at all?
No, it was, I was sent to talk about the dependency case. The department had gotten involved, and then we ended up talking about the criminal case, and that's when we were retained.
Okay, and would your involvement on the dependency case because of your family law kind of pivot at that time?
Yes.
And was this a capital case at that point?
No, it was a second degree.
At what point did it become a capital case?
When the indictment came down, I don't remember the exact day. I do remember hearing that the indictment came down, and I immediately went, it was like 8 o'clock at night, and I went to the jail and I talked to Mark about it. Was Mr. Sievers your first capital case? Yes.
Do you still do capital cases?
I've done one since State versus Adam Souls. It was capital, but it was non-death.
Okay. Do you know if there are specialized CLEs that you would have to do in order to do capital cases?
Yes.
Have you attended those?
Yes.
Do you recall when you first attended them?
Not with much specificity. I know I did, it was either Death is Different, I posted the CLE, it's part of my Florida bar, but I did attend at least one death penalty CLE during the dependency of Mr. Sievers' case.
Would that have been before the trial?
Yes.
Do you recall at all how close in time or how far from the trial?
I don't, but it's like I said, it's I reported it as one of my CLEs for my reporting requirement to the Florida bar, so it's been recorded.
And at those seminars, did they have presentations on the importance of hiring and using experts to craft a defense?
Somewhat, mostly from my memory, it was the importance of jury selection and mitigation. And so mitigation obviously does require experts, but yes.
Okay, so from your recollection, the main focus was jury selection and mitigation?
Yes.
Do you recall any sessions on crime scene experts or anything of the sort?
I don't.
Can you get one moment, Yara?
Yes, ma'am.
And Mr. Mummert, if it doesn't bother you, would you be able to speak up just a little louder so Mr. Sievers can hear?
Sure.
Thank you. Now, okay. And just to reiterate, you said you didn't recall any sessions on a defense or experts for crime scene.
No, so the Mr. Sievers trial was approximately 6 years ago. This would have been further back in time than that, so I don't have a lot of specific recollection about exactly what was presented, other than they spent a significant amount of time on jury selection.
Okay. Initially, what was your role in Mr. Sievers' case?
Well, initially, I was just the attorney who was going to primarily handle the case. I don't want to speak on Mr. Fega's experience, but I know that I had more recent trial experience than Mr. Fega, and so it was contemplated that I would be the one who would be basically trying the case.
You just mentioned you had more recent experience than Mr. Fega. What was Mr. Fega primarily practicing at that point?
He was primarily doing transactional real estate. He had a general practice, so he did some family law and civil litigation, but day in, day out, he was doing real estate transactions.
Did he have any criminal experience?
Yes, he did.
Now, when the state filed the notice to seek death, were there any conversations, either internally or externally, to come off of Mr. Sievers' case?
I don't recall. And by conversations, do you mean with Mr. Sievers, or do you mean within the firm?
Either internally or externally.
I really don't recall. I remember getting the indictment, going to see Mr. Sievers. We talked about it, and at that time when the indictment came down, I had a pretty good idea that a notice to seek death would be imminent. I don't believe that we had that conversation, but again, it's been many years since that indictment came down.
Okay. Were there any conversations to bring on a death qualified attorney?
Yes.
Was one brought on?
Yes.
Who was that person?
Ultimately, it was Mr. Attorney Gregory Messore.
And how did he come on the case?
I believe Greg reached out to us and offered, and of course we were more than happy to accept the help.
Was there any kind of vetting or interview process?
Again, it was a long time ago. I don't have a lot of memory. I do remember over the years having several conversations with Mr. Messore, and you know, I think we were able to effectively work together.
And at some point, when Mr. Messore came on the case, was Mr. Fega still on the case, or had he passed on at this point?
I don't remember. I'm sorry. I do not remember. I know Mr. Fega passed away in October of 2018, I believe. But I don't remember when Mr. Messore came on the case.
Okay. Prior to Mr. Fega passing away, how were the roles divided in this case? Were you responsible for one thing? Was he responsible for another, or did you just take all of it?
By he, do you mean Mr. Fega?
Mr. Fega.
No, I was primarily responsible for everything. However, you know, Mr. Fega at that time, still being my boss, ultimately had some veto power, but I was the one who ultimately, it was my case, so ultimately it's my responsibility.
So were you the one doing all the research?
Yes.
Reviewing discovery?
Yes.
Looking into any experts, if any, to contact?
Yes.
And you said you were unsure if Mr. Messore was on the case at this point?
Yes, and I'm sure he entered a notice of appearance of co-counsel, so that would probably be the best evidence of when he came on board.
Okay. After Mr. Fega died, how were the duties divided?
It was May.
What was Mr. Messore in charge of?
So Mr. Messore was doing the mitigation. So as I said, I had a significant amount of trial experience, including a murder case. However, I had never done mitigation. So we believed it was best to have the person who's already done the mitigation do the mitigation in this point, just for familiarity purposes.
Were you given did you give any direction to Mr. Messore, or did you just say, go do the mitigation and run with it?
No, we worked together on it, you know, and I'd like to think that I had some input, just the same way that Mr. Messore had input on the guilt and innocence phase.
What input did you have on mitigation?
So one of the decisions we had to make was hiring a mitigation expert. Believe we landed on, oh God, his name is escaping me right now. I do apologize. Jeff Giordano. Jeff Giordano was our mitigation specialist, and you know, we talked to Jeff, and we agreed that Jeff was ultimately a good person to do this job after we had several people who weren't.
So he was not the first mitigation specialist?
He was not.
How many people preceded him?
2.
Do you recall how the time in relation to trial beginning that Mr. Giordano was brought onto the case?
Again, not with a lot of specificity. So I know he was our 3rd mitigation specialist, but again, the exact when, I could not tell you.
Okay. You also mentioned that Mr. Messore had some input into the guilt phase portion.
Yes.
Were you mainly in charge of guilt phase?
I was.
Who made the ultimate decision as it related to guilt phase?
That would be me.
And what kind of input or suggestions was Mr. Messore given?
So during jury selection, Mr. Messore and I discussed every juror, and his input was invaluable. It's always nice to have another lawyer to bounce ideas off of. Okay, you know, did you notice anything about this potential juror that maybe I missed? So in that respect, and I do remember, you know, certain witnesses having conversations. I mean, brief conversations at the table. So yes, Mr. Messore is quite helpful.
Was his role limited to jury selection?
No. Again, we discuss witnesses, and you know, and this was a long time ago. I apologize.
Okay.
I believe we discuss some witnesses, and I think he had some input even into my closing argument. But again, this was so long ago.
Do you recall if he assisted prepping any witnesses or helping with cross-examinations at all?
No, I did all the cross-examinations.
Who participated in depositions?
Mainly me.
Do you recall if Mr. Messore went to any of them?
I do not recall.
Now, this case was initially tried with Mr. Rodgers' case.
Yes.
How was that working relationship with Mr. Rodgers' team?
I'd like to think we had a good working relationship. Ms. Fitzgeorge, who was the lead attorney on Mr. Rodgers' team, she was actually my supervisor while I was at the public defender's office. And you know, she's certainly someone with whom I respect and have great admiration for, and she was very helpful, knowing that yes, this was my first capital case, giving me advice, and I will be eternally grateful for her assistance.
You said she would give you some advice. Do you recall if there was a specific area you would reach out to her about?
Just about I know she gave me advice, you know, you should probably go to this CLE. I think it was, might have been Death is Different. But you know, I certainly followed her lead in depositions. And we had, over those years, we had a lot of conversations about this case.
Would you find Ms. Fitzgeorge took the lead in depositions a majority of the time?
The majority of the time, yes.
Okay. Do you recall if there were any conversations, if Mr. Rodgers had any any information that could either help or hurt Mr. Sievers?
I do not recall.
Do you recall if there were any shared theories?
Oh, yes. Yes, we definitely had some shared theories. But our cases were very different.
How so?
So, Mr. Sievers' case was more about the conspiracy, about the prepaid phones, about the communication with Mr. Wright versus Ms. Fitzgeorge's case, which had a lot more to do with forensic evidence, crime scene, the jumpsuits, where the jumpsuits were deposited, the cell phone tracking records. You know, because our clients were 1,000 miles away when the murder occurred.
You just kind of made a line between kind of like forensics with Mr. Rodgers' cases and not forensics with Mr. Sievers' case.
Yes.
Did you find forensics more so irrelevant for Mr. Sievers?
Yes and no. So, in the strictest legal sense, it was irrelevant what actually happened in the house. If we look at 401 and 403, being that it was my opinion, and Judge disagreed with me, that the prejudicial value of most of the forensic evidence outweighed the probative value. I mean, this was horrific, this was gory, and you know, our case really just depended on, you know, whether there was a conspiracy and whether a series of phone calls had happened. We didn't need the records of how the tow truck towed the car from wherever the enterprise was down to Florida. That wasn't really relevant. How the jumpsuit ended up at the side of the road, that wasn't really relevant. However, I understand that they were co-defendants. This was all evidence in the same set of charges, and so in that respect, yes. Although, you know, I personally believe that the prejudicial value outweighed the probative value, and therefore, you know, a lot of this evidence I felt really put Mr. Sievers in the position of having the jury judge him more as a person rather than for what he did. And, you know, one of the jury instructions is you should not decide this case if you are angry at anyone or feel sorry for anyone. And I believe a lot of the evidence that came in did exactly that. And so it was our position that in Mr. Sievers' case in chief, a lot of the evidence was kind of extraneous, but it got in.
Okay. Kind of going off of that line of thinking, did you find that experts had a role in this case? Or did you find a role for experts in this case?
Yes, Ms. Lyons was our expert witness who testified about she was the Sievers estate planning attorney, and you know, she actually was very helpful, and that the jury found that the murder was not committed for pecuniary gain. And so, yes, Ms. Lyons was invaluable in our defense. But you know, as far as our theory of defense, she was the expert who was the most pertinent to our side of the case.
Do you recall if you consulted with any other experts?
Yes. I know we consulted with, I believe it was Dr. Underwood. Dr. Underwood met with Mark on a couple occasions, ran a litany of psychological tests. I believe it was a MMPI. There were other cases where he was looking for essentially mitigation evidence.
So that would have been a mitigation.
That would have been a mitigation expert. I don't believe Mr. Underwood ever generated a written report. I'm unsure of that, but I know he was deposed, and the state had an opportunity to kind of get his findings.
Do you recall any experts as it more so relates to guilt phase?
Other than Ms. Lyons, I don't.
Do you recall if you spoke to a crime scene expert?
I do not.
Would the name J.D. Thomas sound familiar?
It does. And again, I may have spoken to Mr. Thomas, but again, I don't recall that conversation with any distinct recollection.
Okay. Moving forward to kind of the pretrial portion, were you aware of the media attention this case garnered?
Yes.
Did you follow the news?
No, it followed me. I would get people, oh, I saw you on the news. Great. You know, just like I'm sure I'm going to hear about this tonight and tomorrow.
Did you ever consider filing a motion to change venue?
We did. We did.
Was one ultimately filed?
No.
Why not?
Because ultimately I made that decision. And so when you change venue, you don't get a say to where the venue actually lands. So we could have ended up in Collier, Polk County, Hendry, Glades. We didn't really get a choice. And when you don't get a choice, again, you're dealing with the unknown. And had we ended up in, say, Glades County, this would have been everywhere. We could not have gotten a jury in a Glades County. Had we ended up in Collier County, we would have actually ended up with a more conservative demographic. And so we had these conversations, and ultimately I made a strategic decision to not change venue.
Okay. Do you recall if you researched or considered filing any other motions pre-trial?
I mean, I filed a bunch of motions. I filed motions in limine. I mean, can you be a little more specific, please?
I'll come back to that question. Hey, one moment, Your Honor.
Yes, ma'am.
just want to fast forward to Mr. Curtis Wayne Wright. What was Mr. Wright's role in this case?
So it is my opinion that Mr. Wright was the only person swinging the hammer, that he was the murderer, and that was based on the some of the crescent-shaped bruises and lacerations on Miss Sievers' skull were all the same size. So he was also the government's star witness, and he got an advantageous plea deal in exchange for his testimony.
And what was your plan for dealing with Mr. Wright, or putting forth your theory of his involvement?
Well, my theory was basically that he was willing to lie in exchange for the best possible outcome. And when you look at his testimony, first time the police talked to him, he said, "I wasn't there." And the next time, "Okay, I was there, but I didn't go in the house." And then it was, "Okay, I was in the house, but I wasn't in the room." And then it was "Okay, I was in the room, but I didn't swing the hammer." And then it was, "Okay, I was in the room and I swung the hammer maybe once or twice, but that was it." And so we had multiple inconsistencies, and there's no way to reconcile those inconsistencies to say that it was mistaken. No, these were lies. These were lies. And even, I believe, in his proffer, Mr. Hunter said, "You are not being truthful." So essentially, one of the jury instructions is, again, you should consider the truthfulness of the witness's statement. Specifically looking at, did the witness ever make a prior statement that was inconsistent? And in this case, Mr. Wright absolutely did. And it was very clear that he made these prior inconsistent statements, these lies, in exchange for an advantageous plea deal. And that was not rebutted.
Do you recall if you considered consulting with an expert to advance your theory?
That he lied, that it was recorded. I mean, there was no need for an expert. This was, he gave 5 separate inconsistent statements that one of them could not be true if the other one was. There was no need for an expert. These were lies. Everyone knew they were lies, and yet I cannot see how an expert would say, "Oh yes," when he says he was not in the house, and he said, "Oh, I hit Dr. Sievers with a hammer." There's no way for both of those statements to be true.
Okay. Did you have any desire to speak with Mr. Rodgers?
I don't know. So I learned after the trial that Mr. Rodgers had changed his story. I learned after the trial that Ms. Shoemaker had changed her story. And obviously that prior to trial, that would have been helpful, but I hadn't. Yes, my short answer is yes. I would have liked to have spoken to Mr. Rodgers. However, he was represented by counsel, and in order to speak to him, I would have to get Ms. Fitzgeorge to agree to allow me to.
Did you make any attempts to do so?
I did not. I did not, because I know that she, her client was facing the death penalty the same way as my client, and Ms. Fitzgeorge is a fierce advocate for her clients.
And then lastly, do you recall how records were shared in this case between your office and?
Okay, so we originally, when this case was going on, I'll fast forward. Currently, records are shared from the state to defense. There's a kind of a portal, and you download it. If it's a bigger file, then there's a Axon evidence that you can download these files, and if it's really big, you bring a big flash drive to the state and they give it to you. In this case, we got CDs. It was long enough ago where people were still using CDs. And so I had a big file of CDs. And so at the time, my office was at Winkler and Evans, and we had an entire room at the office that was just dedicated to Mr. Sievers' case. That was all that was in the room. We had trial clothes in there, some paper evidence, but that was the room. And so I don't believe we would have emailed evidence. A lot of this evidence, especially, I remember there were some paper medical records that the court ordered to us to basically not disclose to anyone. Those have since been destroyed.
Let me ask a better, more generalized question. Was all the evidence mainly stored in your office?
Yes.
And then if somebody needed to look at it, would they have had to come to your office?
Yes.
Okay. Do you recall what your email was when you were with Fega Law?
I had a couple. mmummert@fegalaw.com and then mmummert@mslawpllc.com.
Okay. Do you recall what Jennifer Mummert's email was?
It would have been probably J. Wood, which was her maiden name. I don't know if she ever got a J. Mummert. It's possible.
Okay. I'll pass witness.
State.
Good morning.
Good morning.
You testified that you've been practicing law since 2005, is that right? And you worked at the public defender's office for 8 years?
Yes,
Miss Fitzgeorge was your supervisor.
she was.
You learned a lot from her.
I did.
And 7 of those years at the public defender's office were spent in the felony division, is that correct?
Yes.
And I think during direct you described your trial experience as significant.
Yes.
You had well over 30 felony jury trials by the time you left.
Yes.
And then you went into private practice, right?
I did.
You talked about the Fega law firm and how you came about to represent Mr. Sievers, but your firm was actually representing Mr. Sievers in a number of different actions. Is that correct?
Yes, we had his probate. There was the wrongful death, the felony, the dependency. I think that's 5.
And so all of those separate cases, your law firm was involved with representing Mr. Sievers.
That's right.
And that included his murder case.
Yes.
What we're here for today. And you primarily were responsible for handling the criminal case, correct?
That's right.
Is it fair to say that you had a good rapport with Mr. Sievers?
I'd like to think so.
You visited him in jail weekly?
I mean, not every week, but pretty close. Generally, on most Sundays were the days where we would go and we'd see Mr. Sievers in the jail and spend a couple hours with him.
Okay, so these weren't short visits.
No, they were not.
You said they would span for several hours at a time.
Generally, yes.
And away from your visits at the jail, you spent a lot of time working on Mr. Sievers' case.
I can't even begin to calculate how many hours. Between court, research, prep, depositions, yes,
Mr. Sievers wanted you to represent him, is that correct?
yes,
And he knew that you were not death qualified.
yes, that was no secret.
Okay, and there was actually a court hearing about that, right?
There was,
He was explained the benefit of having a death qualified attorney,
he was,
but he had retained your firm and had you representing him.
yes,
Despite the knowledge of the protections in place of having a death qualified attorney, he wanted to proceed with you as his counsel of choice.
he did,
And he wanted you to represent him so much that he didn't mind that you were not death qualified.
that's right,
While you were not death qualified, you felt that you had the knowledge, experience, and ability to represent him.
I did,
You would not have represented him had you thought that you would not be able to provide competent representation. Is that correct?
that's right,
And you touched on the decision ultimately not to change venue in this case, or move for a change of venue.
yes.
Is that something that you went back and forth on?
It is. And I actually went so far as to draft the motion. I believe I started looking for, you need 2 witnesses to testify that they've heard of the case and they're familiar with it. So I know I had a couple affidavits drafted, but ultimately, this is one of those things I just went back and forth on, and ultimately, when I thought about it, it made the most sense to me. I mean, everything that's unknown is a calculated risk, and to me, leaving venue here in Lee County, Florida, I believed benefited Mark the most.
So that was a strategic decision that you made
Yes,
after weighing all of your options.
yes,
And you didn't represent Jimmy Rodgers, right?
at no time did I represent Mr. Rodgers.
But you are aware that his trial was also local.
Yes,
You talked about attending a CLE seminar. I believe it was
life over death. Yes,
Life
that's
over
it.
death.
Thank you. Yes,
and that you learned about jury selection during that seminar.
yes,
Did you follow that paradigm that you learned during the seminar and apply that to Mr. Sievers' case?
I did.
And you also had Mr. Messore assisting you during jury selection.
Yes, I did.
You two spoke about every potential juror.
Every last one.
Did you ever feel like you needed to hire a jury selection expert to assist you?
No,
Had you felt that you needed an expert, would you have sought one out?
if I felt like one was necessary, I would have.
Okay, and Mr. Messore did handle the penalty phase aspect of the case that was in front of the jury, right?
Yes, I did the Spencer hearing, but he did the jury portion.
Okay, so you did the Spencer hearing that was part of the penalty phase in front of the judge.
Yes,
So you were still involved in the penalty phase preparations.
I was.
You spoke with a different mitigation specialist.
Yes, 2 prior.
Okay, and then you ultimately retained a
Mr.
third one.
Giordano.
You mentioned that you had a room in the office that was dedicated entirely to Mr. Sievers' case. Is that correct?
That's right.
Did you make that room available to your mitigation specialist?
100% yes.
You gave them access to that room if they needed to
Yes.
have to get any of the materials.
Yes.
And you mentioned that you had Mr. Sievers evaluated by Dr. Underwood.
Yes.
You were present for those evaluations and meetings?
I do not believe that I was. So I do recall one of the one of the diagnostic tools was the MMPI, which is the Massachusetts Multiphasic Personality Inventory. That has close to 1,000 questions that you write down. And watching Mr. Sievers fill out the MMPI, I think is going to be more helpful to a psychologist than a criminal defense attorney.
Okay. Do you recall attending any of the meetings between Dr. Underwood and Mr. Sievers?
I believe I was there for their initial meeting. You know, I want to just make sure that if I'm introducing someone to Mark, that that there's good chemistry there. That you know, I want to make sure it's a good fit. That they're going to work effectively together.
So is it fair to say you didn't actually observe him, Mr. Sievers, filling out all the questionnaires, but you did take part in some of the process of the evaluation?
Yes.
Okay, and ultimately, Dr. Underwood did not diagnose Mr. Sievers with anything that would have been helpful in his mitigation phase.
No. So for mitigation, things that would have been helpful, schizophrenia, bipolar type 2, you know, things like that nature that, okay, you know, even if the jury were to find someone guilty, okay, well, you know, maybe this is something that due to, you know, a mental illness, they were, you know, this person did not really have as much of the capacity to appreciate what they were doing. But no, there was none of that.
Is that the reason why ultimately Dr. Underwood wasn't called to testify in the case?
Yes, we don't need an expert to say that you know, Mr. Sievers has you know, no mental health issues.
Fair enough. And there was a mention on direct of a expert named J.D. Thomas.
Yes.
But you don't really recall the interaction.
I really don't.
Okay.
I really don't.
You had phrased the theory of the case and explained that there was a lot of extraneous evidence during the trial that you did not feel like related directly to your client, Mr. Sievers.
Yes.
If you had a crime scene expert testify, do you feel that it could have potentially fallen into the aspect of being extraneous rather than helping your client?
I do. Just at a certain point, you hit diminishing returns, and I cannot say in good conscience that okay, a crime scene expert would have been necessarily very helpful to Mr. Sievers' portion of the case. Our theory has always been that there was no conspiracy, not that there was no murder, not even that Mr. Wright did not commit the murder, just that there was no conspiracy. Our theory of the case is that if it was designed to look like a home invasion robbery and there was $30,000 in cash in the house, why wasn't that taken? If the purpose of this is a murder for hire, why was the murder carried out in the least efficient way possible? And it looked more like anger and rage than somebody who came to take life very efficiently and escape without notice. There were the inconsistencies with the state's theory of the case that this was a murder for hire, and I still believe Mr. Sievers is innocent, and I'll go to my grave believing that. It just didn't make sense. That and the fact that Curtis Wayne Wright was a known liar, and the jury knew it. And yet I think some of the photos of Dr. Sievers were some of the worst photos I've ever seen. And I think at the end of the day, and this is just me speculating here, that the jury was moved to either anger or sympathy over the manner in which Dr. Sievers was murdered.
If I may just have a moment.
Yes, ma'am.
You mentioned the what you referred to as gruesome autopsy photos and crime scene photos. You actually attempted to get those excluded from evidence, right?
Yes.
And you were not successful with that.
I was not. So it was my theory. There was no question that she was dead. There was no question that she was murdered. There was no question about the manner in which she was murdered. The question was Mr. Sievers, was he the mastermind? Was did he orchestrate this? And ultimately the gruesome autopsy photos didn't advance the state's theory that yes, he was the one who orchestrated that. If there was some evidence that, hey, Mr. Sievers says, hey, I want you to go and murder my wife with a hammer, and that's how it happened, okay, I can see the relevance there. But it wasn't. And so the sole purpose of the gruesome crime scene photos and autopsy photos was to prejudice the jury against my client.
Rodgers never offered to testify in Sievers' case, is that correct?
That's correct. Well, he may have after the fact. I don't know if he has since, but at the time of Mr. Sievers' trial, he had not. Okay.
So when you were preparing for the trial, you never heard from either Mr. Rodgers or Miss Fitzgeorge that, hey, Mr. Rodgers is willing to testify in an effort to help Mr. Sievers?
No, I would have remembered that, and I would have taken Miss Fitzgeorge up on that.
Okay. One of your themes was that Dr. Sievers was worth more alive than she was dead. Is that correct?
100% yes.
And you tried to discredit the state's murder for hire theory.
Yes.
You tried to show that the murder was not committed for pecuniary gain.
And I was successful in that.
Yes, the jury ultimately did not find that aggravator, correct?
Yes.
When I asked you about the time that you spent on Mark Sievers' case, you said you couldn't even begin to estimate. I mean, if you had to, how many hours do you think you spent on his case?
I mean, given everything, I mean, over 1,000 hours, and it's not even really close. Just looking at the evidence, preparing, going to court, seeing Mr. Sievers in the jail. It was a very, very time-intensive case.
Okay. Did you also have Mr. Al Olson working with you?
I did.
And he was part of your defense team?
We had Mr. Olson as our private investigator, yes.
Okay. And does a Mr. Tom Matthews ring a bell?
Yes, Mr. Matthews was, I believe, an accountant.
Okay. And he would have been someone that you possibly consulted with?
I believe we did, just to kind of look over the Sievers finances, and everything indicated that the Sievers family was doing well financially. It looked like they were more spenders than savers, but they lived a nice lifestyle. They did the things they wanted to do. They bought the things that they wanted to buy, and as far as I could tell, all of their bills were getting paid, and the Sievers family was not in any dire financial trouble.
You mentioned that you felt that Mr. Wright was infatuated, or I'm sorry. No, I'm sorry, did you mention that Mr. Wright was infatuated with Mr. Sievers?
I believed he was, yes.
Okay. Sorry about that. I couldn't remember at the time. Okay. So why did you believe that he was infatuated with Mr. Sievers?
So there were some text messages that just heterosexual friends don't send to each other. You know, like little pet names and things like that. That just, it kind of struck me as this may have been a relationship that, you know, maybe Mr. Wright may have wanted something more out of the relationship.
Sievers never admitted to you that he had a relationship with Mr. Wright, though, correct?
He did not, no.
Okay. And are you aware that he actually denied having a relationship during his evaluation with Dr. Underwood?
Yes.
But you were aware that there were potentially some allegations that there was a relationship there?
Just the text messages. Just there were some text messages about, hey there, sunshine, is it up? Referring to like morning erections. It just, you know, just kind of bizarre.
Did you choose not to focus on that information and have the jury hear that information?
I did.
And why was that?
Well, a couple reasons. One, it was my belief that Mr. Sievers wanted to effectuate his constitutional right to remain silent. And for me to really get into that, that would have required Mr. Sievers' testimony. Also, I don't know how a jury is going to take that evidence. And if you're not sure, and you're the defense, and you know that the state carries the burden of proof, then you're not going to introduce a new element into the trial that, you know, if there are people on the jury who are homophobic, maybe they hold that against Mark. Maybe they judge Mark based on homophobia and not on the facts and the law.
In addition to possibly having a bias against being homophobic, would it potentially introduce a motive that may not have existed in their minds before?
It absolutely could have. It absolutely could have. And so it just, it ultimately, it didn't make sense to, you know, to just introduce something that I don't know how the jury's going to take it, and I don't know if it could actually make my case worse.
So that was a strategic decision by you not to introduce that evidence and proceed on a theme of that sort.
Yes.
That there was a sexual relationship.
Yes.
All right. During the deposition a few weeks ago, you cried. Is that correct?
Yes. Thank you.
That wasn't the first time that you cried about this case, was it?
No,
You care very much about Mr. Sievers,
I do.
and you care about his case.
I do.
You followed what was going on with his direct appeal.
Yes.
You watched his Florida Supreme Court argument.
No, I actually believe I had court at that time that conflicted with that.
You didn't travel to Tallahassee to?
No.
Okay.
I did not.
But you did
I followed it.
follow his case. And you feel that you did everything you can to represent him adequately
I do. I also feel like I failed.
because you didn't get the result that you were hoping for.
Yes.
If I may just have a moment, Your Honor.
Yes, ma'am.
I'm ready, Your Honor. That's okay.
You may
May I-
proceed.
Thank you, Your Honor. There was actually a written stipulation between the defense and the state to not go into the sexual or alleged sexual relationship between Mr. Wright and Mr. Sievers. Is that correct?
I believe so, yes.
Okay. And going back to when the state initially sought to seek the death penalty in this case, you actually moved to get the indictment dismissed. Is that right?
I did.
Okay. I have no further questions, Your Honor.
Defense.
Yes, briefly. On cross, you mentioned that you had never heard from Mr. Rodgers or Ms. Fitzgeorge that Jimmy had wanted to testify.
That's right.
And you stated you never represented Mr. Rodgers.
Yes.
Did you have a release from Mr. Rodgers?
Like a release of...
Information?
No.
No. On direct, you stated that at some point Mr. Rodgers had changed his story. How are you aware of that?
I believe I saw something in the news.
Okay, so that's from extraneous information?
Yes.
Okay. Did you ever order the transcripts of Mr. Rodgers' trial?
I did not.
And do you recall the other mitigation specialists that were on the case before Mr. Giordano?
Cynthia O'Shea and Donna Murray.
Okay, one moment, Your Honor.
Yes, ma'am. Any redirect?
Yes, Your Honor. Mr. Mummert, you watched some of Mr. Rodgers' trial, is that correct?
I watched most of it.
You did? Was that in court?
No, I had it on in my office while I was doing like last-minute trial prep for Mr. Sievers' case.
Okay. And you also sent some of your defense team to be there in the courtroom as well, if you recall.
I don't recall, but
Okay.
I recall I had a lot of time to myself with no interruptions, so that's likely.
Okay. But you do recall catching a majority of what was going on in his case?
Yes.
And his trial was prior to the trial in this case?
Yes.
No further questions.
Anything further defense? Is this witness to be released or retained?
We asked he be retained in case he needs to be recalled.
Mr. Mummert, you're subject to recall. We'll let you know if you need it.
Can I go back to my office?
I would think you have his number,
Oh,
correct?
absolutely, absolutely.
I think you're good.
Thank you.
With that, why don't we take a 5-minute recess, let everyone stretch their legs, use the restroom if they'd like to, and 5-10 minutes.
Thank you.